Hello everyone, welcome to today's news charter. Let us begin with the prelims practice question. Look at this question. Three statements are provided. It is a question from modern history. Consider the following statements regarding the Treaty of Yandabo, which was done in 1826. Three statements are provided. Let us read the statement. Statement number one, it ended the Second Anglo-Burmese War. The second statement, Myanmar would renounce all claims to Tripura and Mizoram. And the third one, Assam would be annexed to British-ruled India. First point, if you have read modern history properly, you would easily be able to answer this question because it is a very major topic in modern history. Treaty of Yandabo was done after the first Indo-Myanmar War, not after the second one. So this statement is incorrect. The second statement, Myanmar would renounce all claims to Tripura and Mizoram. Such a thing did not happen. So this is also wrong. But Assam would be annexed to British-ruled India is a right statement. So the answer is only one statement is correct. Let's move to the topic of the day. Parliamentary privilege is not applicable to legislatures who were involved in bribery, who had received bribes. The Supreme Court has recently told in a verdict that parliamentary privileges will not be applicable to those people, those legislatures who have got bribe to ask a question or to vote in a particular manner or to do anything in the parliament. So this should not have been there in the earlier point itself. But sadly, in 1998, there was a very important case, the JMM bribery case. In JMM bribery case, the same Supreme Court told that parliamentary privileges are applicable to any kind of legislature. Any legislative member will come under parliamentary privilege, even it is proven that he has got some bribes. So you cannot arrest him when the assembly is going on. So certain provisions are there for parliamentary privileges, which we will look at later. So the Supreme Court told that parliamentary privileges are applicable to them too. But recently, the Supreme Court has clarified that the earlier verdict was wrong, and any legislature, any minister, or any member of the Lok Sabha or Rajya Sabha or state assembly, if they have involved in bribery, if they have got money to do something in the legislative, then parliamentary privileges will not be applicable for them. So this is very clear. Parliamentary immunity would kick in only if the legislature acts so that it is going to help the democracy. Parliamentary privileges are made so that a legislative member do not have to worry about arrest or heavy-handedness of the government when they are trying to do something which is good for the country. So only in such cases parliamentary privileges is applicable. In other cases it is not applicable. What exactly is parliamentary privilege? Parliamentary privilege is mentioned in Article 105 of the Constitution, in which it is mentioned that the member of parliament are exempted from any civil liability. So this point is very important. Civil liability only, not in other cases. If it is a criminal case, in such cases, we cannot mention that he can be left alone. It is applicable only in case of civil liability for any statement made or done in course of their duties. Also, if a member has done something in the parliament in the course of his duty, if he had told something which is against the government, in such cases, he cannot be arrested. So this is mentioned in Article 105. Parliament has not made any special law according to this. They wanted it to be discretionary in nature. That is why they have not made any law until now. Freedom of speech in Parliament is guaranteed under Article 105. Apart from this, other things are also there which we need to know. Article 121 of the Constitution has restricted from discussing the conduct of judges of the Supreme Court or High Court in the Legislative Assembly or the Lok Sabha or Rajya Sabha. So the way in which a High Court judge or Supreme Court judge has acted, all these things will not be discussed because we need to keep the legislative and the judiciary separate. Doctrine of checks and balances. The members enjoy freedom from arrest in any civil case 40 days before and after the adjournment of the legislative assembly or the Lok Sabha or Rajya Sabha. So whenever the parliamentary sessions are going on, 40 days before the session starts and 40 days after the session starts, in this time period, no one can get arrested, even if it is a civil case. So this is in order to provide some respect to the legislative of the country. No member can be arrested from the limits of parliament. So within the parliamentary limits, a member cannot be arrested. Other than this, if a member is going to get detained, the speaker or the chairman of the Lok Sabha or Rajya Sabha, respectively, should be informed before the arrest. There are certain exemptions also when we talk about parliamentary privilege. If the arrest has to be done under Preventive Detention Act, if the arrest has to be done under the Essential Services Management Act, if the arrest has to be done under National Security Act, because these acts are extremely important for the law and order of the country. So in such cases, parliamentary privileges will not come into force. So this is something which we need to know. No person shall be held liable for publishing any report or discussions of the House under the authority of a member. If a member has given the authority to someone to publish certain things, then that person will not be liable for breach of privilege. Power and right to exclude the strangers from the proceedings of the House, because when the proceedings are going on in a house, strangers will also be present, normal people will also be present, but if the legislature wants, they can tell or restrict these people from the proceedings. Another very important news for today, Narsapur crochet was in news. They have provided GI tag for Narsapur crochet. So what exactly it is? An estimated 60% of the artisans involved in the craft are actually women. Narsapur is a place in Andhra Pradesh and they make this traditional crochet. It is a handmade, hand-woven cloth craft. So 60% of the people involved are women. 15,000 women are totally involved. So providing a GI tag to this art is going to protect the livelihood of these many people and their family. Nashapur crochet lace has found great demand in foreign countries also, Europe, UK, France, Japan, USA, etc. Almost 85% of the production is actually exported. So this clearly shows how much important this is. So from prelims point of view, try to remember Narsapur crochet and it is from Andhra Pradesh. It has been provided the GI tag. The recent threat to this is Chinese machine made crochet. They have caused a lot of problem to this. So the government has come up with providing GI tag. WTO's Ministerial Conference 13 got completed very recently. So what are all the major outcomes from this 13th Ministerial Conference from prelims point of view? Where did it happen? In Abu Dhabi. 14th Ministerial Conference is going to happen in Cameroon. The ministerial conference will happen once in 2 years. Before this, the 12th ministerial conference happened in Geneva, Abu Dhabi, and then Cameroon. Try to remember this order. So what are all the major outcomes? When we talk about e-commerce, India has been telling that e-commerce should also be allocated with taxation. So recently, in this WTO Ministerial Conference 13, the countries have agreed to extend the e-commerce moratorium for next 2 years. So for the next 2 years, they are not going to give any taxation, apply any taxation for e-commerce. When we talk about fisheries, India and certain other countries have been demanding that we should not reduce the subsidies for fisheries. So it has been mentioned even in the Geneva conference that fishery subsidy should be reduced because we are exploiting fishes to a greater extent. So recently in this conference, nothing happened. They told that they didn't come up with any conclusion when we talk about fishes. But one major problem for India was when we talk about public stock holding for food products, even for that, we have not come up with a conclusion. India has been claiming that when we talk about public stock holding, the developing countries should be given some leniency so that they can stockhold the food products whenever there is a necessity, they can take care of it. India has been asking for relaxation when we talk about the minimum support price also. Even for this, we were not able to come up with any conclusion. So these are all the major details we need to remember. The most important point is nothing important happened in WTO conference. So this itself shows how bad the situation of WTO is. Mains question of the day, critically examine the relevance of WTO in the present times. So this is what I was telling about. WTO is not in a good position because countries were not following the rules of WTO. WTO was very strong earlier. At present, it is not because it has been dominated by the developed countries. Developing countries have always been claiming that we are not given a voice in WTO. Apart from this, WTO's resolutions and decisions were mostly targeting the developing countries. So these things you can mention and you can tell that we need wider representation in WTO. The more importance given to developed countries such as US, UK, etc. should be restricted, and countries such as India, Russia, and uh, China, South Africa, these countries should have more say in WTO. Very important point for mains examination. Cervical cancer has been in news regularly. India also came up with a new measure to prevent cervical cancer. So there is a very good solution given by the WHO, that is 90-70-90 triple pillar intervention. According to this, 90, the first 90 means the WTO telling that 90 percentage of the girls below the age of 15 should be fully vaccinated. 70 means 70 percentage of women must be screened using a high performance screening test by the age of 35 and again by 45. And the third 90 means 90 percentage of the women detected with cervical pre-cancer and cancer lesion must be provided treatment. 90 percentage should be vaccinated, 90 percentage should be given treatment if they have cancer, 70 percentage should be screened to analyze if they have any problems. So you can make use of this point in your mains answer writing. So that will be all for today. Thank you. All the best. Study well. Let's meet tomorrow.